And the next case is MINNEY versus State of Florida. Mr. Cushman, you can approach the podium if you want. Get yourself set up. You want to reserve any time, sir?
Yes, sir. I'd like to reserve about 5 minutes.
You've got it. You may proceed, sir.
My name is Tom Cushman. I represent DESIRAE MINNEY. This is a search warrant case. And many years ago, Benjamin Franklin said, half-truth is all a whole lie. I think this case is a good example of that maxim. In this case, the detective doing the affidavit with the search warrant left out the significant fact that the date of the controlled buy had been almost 10 months previous to the application for the warrant.
How long a period of time? Is there a blue line that you found in any cases that indicates when something becomes stale?
Yes, sir. I think pretty much the line has been drawn at 30 days.
It's not in any statute, though?
It's not a statute, but it is in the case law.
What's the longest case that you found?
I think it was about 43 days. Now, there are other cases dealing with staleness, but going beyond the 30 days is pretty much unheard of, except now there is another line of cases dealing with child pornography, but the nature of that type of evidence and the statements that child pornographers often come back to that is different. In a drug case, and there's a case called Cruz that deals with the, actually there's 5 criteria, and that comes out of Illinois versus Gates. But the first is the pattern of ongoing criminal activity, which I suggest here is extremely lacking. The nature of the object being sought, in this case, drugs. If you're looking for child pornography, it may be kept significantly longer, but the cases seem to diverge, drugs versus child pornography, and you're dealing with a much shorter period of time. The nature of the criminal activity, and Cruz and Gates indicated if they were growing marijuana, obviously it might be a little bit longer. 4, whether there's a continuing flow of information about what's going on. In this case, the detective said he conducted drive-by surveillance, and with that he could tell whether or not there was cars in the air. That's all he could tell. He did a series of trash pulls at the very beginning and found a minute amount of marijuana in some trash that had no indication of who it belonged to. Did 2 trash pulls, then this alleged controlled buy that was 293 days earlier. Supposedly the controlled buy happened. Now, the detective also left out the fact that they could not do another controlled buy. He left out of the affidavit the fact that he said the investigation went cold. He left out the fact that the sheriff's office fiscal year changed, they had no more money, so that stopped the investigation.
And why do you think that those types of facts ought to be in an affidavit for warrant? You know, what you're asking for is a book rather than an affidavit establishing probable cause.
Well, when you leave certain things out, as in a case called Sotolongo out of the 2nd District Court.
I understand that, but the things that you're leaving out, there's a quantification of that, and the budgetary process for the sheriff's office doesn't seem to be a terribly relevant factor. Do you think it is?
No, I don't disagree with that, but the fact is that it resulted in a 293-day delay, and whatever the cause, the delay was too long. Probable cause was long gone, because one of the bottom lines in determining probable cause is whether or not the dope is still there. And we're not talking about some dope that he might have been resupplied. That's where the information comes in. There was no new information in this case. The informant said that he saw some drugs still in the house when he made the purchase 293 days earlier. However, the detective didn't reveal how much drugs he saw, but the question is, was there enough quantity of drugs or contraband involved so large that it could not have been consumed? In a period of 10 months, almost for sure it was consumed. And the nature of probable cause is that those drugs were still there. Not that he might have been resupplied, but that those drugs that the informant saw were still there. That's where the probable cause comes in.
So wouldn't that affidavit have been sufficient if you didn't have anything in there about a confidential informant that had seen the drug going down, drug buy going down and out? If that fact wasn't in there, isn't there enough in the remainder of the affidavit to mount the probable cause?
No, sir, because you have 10 months separating the trash pulls, and the last trash pull was about 2 weeks before the warrant was issued, but it was one trash pull. And again, they found nothing to indicate exactly who that trash belonged to. No mail, no. One time they found a police officer's car.
Is it your position that if they don't have something in the affidavit to establish that the trash belongs to the defendant, that's not sufficient?
I think it's certainly relevant. It's certainly an issue if there's nothing to indicate whose trash it was. Remember, this is a mobile home where there's 4 mobile homes on a dead-end dirt road. There was nothing in this trash to indicate that it came from DESIRAE and MINNEY. There was nothing to indicate, and their surveillance did not indicate who lived there, how many people lived there, what was going on, and they also left out the significant fact that DESIRAE MINNEY was gone. She was gone for a significant period of time. They don't know how long, but in the last sentence of the affidavit, the detective put in there that DESIRAE MINNEY has continually lived there. Later on, he contradicted that in the hearing and said, well, she was gone, we don't know where, we don't know when, we don't know when she left, we don't know when she came back. And that's a significant leaving out also. And as in Sotolongo and in Young, there's a statement that it's not what was in the affidavit, it was what was left out that was significant. And I'm suggesting that leaving out the date was not an oversight. It was an intentional ploy by a 13-year veteran of the narcotics force. He knew what he was doing.
The trial court didn't make that finding, did they?
Didn't make the finding.
Did not make a finding that there was an intentional.
No, sir. I'm suggesting that you can draw that conclusion from the facts, because he put in the dates of the first trash pulls. He put in the dates of the last trash pulls. What he left out was the date of the controlled buy. And there's a line of cases that say leaving out the date is significant, and it's fatal to the warrant. That's Getro versus State, which also cites King versus State, Rand versus State. They're all second DCA cases. There is one first DCA case that says you leave that date out, it's fatal to the warrant. I'm suggesting that that is the law of the state of Florida and should be the law, and that this court should find that leaving out that date is fatal to the warrant and reverse the conviction. Thank you. I'd like to reserve the rest of the time.
Thank you, counsel. Ms. Jolly, you may proceed.
Thank you. Good morning. May it please the court. Mary Jolly on behalf of the state of Florida. The standard, I think what we should look for here is the trial court did a detailed order making specific findings, and the standard under Illinois Gates is the totality of the circumstances. Within 30 days of the execution of the warrant was the trash pull that recovered contraband along with...
Let me ask you this. If you go to an apartment complex and go to a dumpster in an apartment complex and pull garbage out, pull bags, and you find drugs in one of the bags, there's nothing to tie it to any specific apartment, does that give you any type of probable cause as it relates to any individual within that apartment complex?
Without researching case law, I would have to say I can't answer that knowledgeably, but we don't have those facts.
Well, let me ask you this. This was effectively a neighborhood trash pull. Apparently, all of the folks that lived in this area, these 4 mobile homes, all put their trash out, apparently in the same location, so that there was no testimony that the trash that was actually gone through had any connection with MINNEY, had any connection with the appellant in the case. So it becomes what's effectively a neighborhood trash pull, where you're taking all of the trash that all of the neighbors put out, and you're going through it, and you're finding in one of the bags some stems, some seeds. You found, part of a joint in one of the bags, but there's nothing to tie it to the appellant, as opposed to any of the other 3 mobile homes. It becomes a neighborhood trash pull. Do you have any case law that would support finding probable cause under those circumstances?
Not a specific case on a neighborhood thing, but we have to, again, Judge Cohen, look at the totality of the circumstances here. We have additional facts here. We have the fact that the confidential informant did that controlled by.
It was 10 months. That was 10 months earlier.
Correct, but that, coupled with the fact that you have surveillance of the officers seeing cars going to this mobile home at different cars, different times, he testified that ongoing activity occurred during the entire time period, and you have specific calls about that residence that would increase.
That the detective that did that affidavit, you don't think that the judge would have wanted to know that that controlled by was 10 months ago?
The record demonstrates, and it has not been appealed, that he did inform the judge. It's at the hearing on page.
He informed the judge.
He volunteered the judge that the controlled by on the transcript of page 141. I'm sorry, I didn't mean to interrupt. That the controlled by was not within 30 days. This notion that this officer.
I'm sorry. How did he inform the judge of that?
When he went to sign, when he presented the affidavit to the judge.
Are you suggesting that we go outside the 4 corners of the affidavit?
I'm not suggesting, no, absolutely not. Not for purposes
Should the judge have done that?
But when there's an argument that this officer acted in bad faith or he deliberately omitted evidence, he hasn't appealed that hearsay statement of it, that came out at the suppression hearing. I think it demonstrates not a bad faith on the part of this officer. No, we don't need to go beyond the 4 corners here because I think we do have the sufficient.
Do you think that the judge should have? Should the judge even have been talking to that detective about facts outside the 4 corners of the affidavit?
I don't know whether there was a discussion or if it was just sort of an unsolicited comment by the officer telling the judge that. It's in the record. It's at the suppression hearing at 141. It doesn't demonstrate what context it came up. However, I do think the judge had enough here based upon the trash pull and the fact that what precipitated this last and final trash pull was the fact that these complaints from the neighborhoods about that specific residence increased daily. That precipitated trash pull number 3. And it's our position that if you look at the totality of the circumstances, which this trial judge had before him, he had that other evidence, the 2 prior buys, the controlled buy, while they alone, we're not saying those were, within 30 days we had that other information really bolstered the fact that the totality of the circumstances had demonstrated that there were drugs being sold from this residence. I think the
trash pulls, he had nothing. You couldn't connect those trash pulls with the defendant below, with the appellant in this case, in any manner, can you?
You can connect it in the context of you knew she was living in that residence and the trash, all of that trash came from that residence.
How do you know that? Where in the record does it establish that trash, that the seeds and the stems were found in, came from that residence?
Well, she concedes she had standing and that she lived there. No, there's nothing in the record directly that says that bag came from this residence. However, this notion of this neighborhood trash pull, it wasn't briefed in terms of case law, in terms of a collective trash thing. And to be honest with you, Judge Cohen, I can't recollect in the record where there's specific testimony at the suppression hearing that all that trash was pulled. Mr. Cushman can correct me, but I don't even recall that fact, which would jump out at me for purposes of argument. It's our position, though, that within 30 days you have daily complaints about that residence, and you have a trash pull which uncovers this contraband. It's a totality of the circumstances, and it's also even in marginal cases, Judge Cohen, there's a preference for that these warrants stand, and that comes under Illinois v. Gates.
Ms. Jones, have you found any cases that would uphold a search warrant where the only facts were complaints by neighbors, surveillance, cars going there all the time?
Yes, I did a string side of cases in my brief. Off the top of my head, we have State v. Mays, and I left my brief at the table, but they're in my brief where it's one trash pull, surveillance, and ongoing, this notion of surveillance and complaints. Yes, I have cases in my brief that support that that's sufficient.
But I'm asking you whether any of these cases, the facts in any of these cases indicate that there was no trash pull, but there was surveillance, there was a constant traffic pattern of cars going up to the trailer and all. If that's all there was, would it be sufficient?
Yes, I think it would, Your Honor. When you have complaints with different cars at different times, which is evidence of some sort of drug activity, and then you have surveillance of this going on, and complaints that drugs are being sold in and from the house, I think it would be enough, Judge Boyce. Again, it's a common sense, reasonable approach. That's the standard under Illinois versus Gates, and I think there's a preference here. This judge did a very detailed, good order demonstrating his reasons why, and I don't think we should go beyond that. He makes credibility determinations as it pertains to Detective Ferris. It's not this court's role to reweigh that credibility determination. And I think the totality of the circumstances here support that there was probable cause to support the warrant. And we'd ask that this court affirm the order denying the motion to suppress and the judgment and sentence. And unless you have any other questions, thank you.
Counsel, do you agree that there were daily complaints?
No, sir, I don't. As a matter of fact, the testimony was subject to a good deal of cross-examination. At one point, we asked,
What's in the affidavit, though?
sir,
I think he's asking you what's in the affidavit. Did the affidavit say that there had been complaints from neighbors?
said complaints from neighbors, but it didn't say what the complaints were. The fact that cars come and go from a home could indicate a lot of things. Could indicate teenagers live there. That's not against the law. There was no ongoing, continual criminal activity that was documented. What they had was 3 trash pulls over a period of 10 months that showed a little bit of marijuana. Somebody might have possessed a minor amount of marijuana. That's not sufficient to get a search warrant under these circumstances because there was only 1 trash pull. The continual traffic means people come and go. They didn't know who lived there. When they served the warrant, there were 6 people there. Not all of them residents, but there were 6 people there. Some of them had dope, some of them didn't. But the fact that people come and go from a home is not an indication of criminal activity. At one point, the detective said, well, he had cross-examined the fact that he had said there was 6 complaints during the total period. And he later changed that and said, well, maybe they were monthly. But the bottom line is that we're talking about drive-by surveillance anyway. He made no notes, what he saw, when he saw it, who was there. There was nothing to corroborate any of this stuff except the neighbors complaining. Well, what were the neighbors complaining about? We don't know. People coming and going. That's not a crime. And it's certainly not a basis for getting a search warrant. Now, what I want to talk about finally is the lack of probable cause, because the drugs that the informant saw 10 months earlier could not have still been there. And the probable cause has to relate to what that informant saw. It was clear during the hearing that the detective had no idea what probable cause actually meant. He had no indication that whoever was selling drugs had resupplied themselves, had no information about that, no intelligence, no surveillance, nothing to corroborate that. He said basically that 5 minutes after the sale was made, they had no indication there was more drugs there. And without that, there's no probable cause. And that's
under that theory, I mean, if you have a controlled buy and the law enforcement officer takes the drugs out of the house in return for money, those drugs are no longer there, therefore there's not probable cause. Of course that makes no sense. And there's no court that says it's got to be the exact drug referenced in the affidavit to establish probable cause. Your probable cause is the presence of drugs in general, not a specific ounce of marijuana or certain type of pill. It's the presence of drugs in the house in general that one is establishing probable cause for.
Your Honor, in all due respect, I disagree. The probable cause has to relate to the drugs they saw there then, which is why he put into the affidavit the confidential informant saw the drugs then. And that's what it has to relate to, is to give the court probable cause that there will still be drugs there, but not for a long period of time. And that's where the staleness functions into this. And so Professor Lefebvre clearly indicates, and I put it in my brief, that it has to relate to those drugs then, and that probable cause gets stale very quickly when you're dealing with a limited amount of drugs. If he had 40 tons of marijuana, then maybe it would still be there. But we're talking about misdemeanor amounts of marijuana at best ever, and the real crime was the alleged sale of the pharmaceuticals, not the marijuana. And so all it indicates is that somebody on that street had a little bit of marijuana they cleaned. That's all it ever indicated. There was no other probable cause. There was no continuing surveillance. There was no intelligence. There was nothing to corroborate what the detective said. We know he lied. We know he said that Desiree Minnick lived there continually. And when later on he said, no, she didn't. We know that he played fast and loose. There was simply not probable cause would suggest that the proper thing is defend the citizens, give the Constitution its plain meaning. The warrant was issued based on fraudulent representations by the detective. I ask you, please, reverse this case. Please. Thank you.
Thank you, counsel. We're going to be in recess until tomorrow morning. If the attorneys would like to join us in the attorney's lounge for a cup of coffee, we'd be glad to get you all back there. Thank you.